authorization for a use of chromium trioxide. And again, Bas Eickhout to start with.
Thank you. This is a total other topic, but still also very important because we're talking about the REACH regulation here. And we're talking about a chromic trioxide, which is, and that's undisputed, it's a carcinogen without threshold. And cancer is very much into the attention very lately. This is now exactly about regulating a carcinogen without a threshold. So that means any exposure will have an immediate effect already. So how REACH is then very clear is it can only be authorized if there are two conditions met. One is that the socio-economic benefits outweigh the negative side, and the other one is that there are no alternatives. And especially on this one, on not having alternatives, even EFSA or ECHA has been very clear, and I have to be precise, the socio-economic assessment committee thereof, and they have done an analysis of the applicant and came to the conclusion that their assessment of the alternatives was not sufficient. It was not good enough, and I can even quote, if you want, on how they put that into writing, but given the sake of time I will not do that. So if you are not having alternatives available, then the law is very clear, you cannot grant the authorization. Still, the Commission has done so. And with that, they are going exactly against what the General Court already in other cases has applied, that the burden of proof that there are no alternatives should be at the applicant. And if the analysis is that that has not properly been done, then there can only be one conclusion, and that is that you cannot grant the authorization. The Commission, however, still decided to do so, and therefore is in violation with the REACH regulation, and therefore we propose an objection to that decision.
Thank you. For SND, it was supposed to be Maria Arena. She's not there. It's you? Okay, Mindali.
On behalf of the SND and on behalf of Maria Arena, we agree with the arguments being put forward, and we agree with the co-objectors in considering that the Commission's approach with respect to the alternatives discriminates against alternatives that are already available in certain sectors and also for certain users. And we strongly believe that this amounts to an unlawful derogation to the applicant's obligation to prove that there is no alternative. We reaffirm also the statement that was made pursuant to the General Court when it reached the conclusion that the applicant has not met the burden of proof and that, therefore, in such a case, authorization cannot be given or granted. For those reasons, we will be voting in favour of the objection.
Thank you. For Renew, Martin Oschik.
Thank you very much. I'm not going to go into the health implications, although I believe that non-threshold carcinogen on its own it's a problematic thing. But what I'm upset about and why I co-signed this objection is that it's also this authorization is something which I believe is stifling innovation. The applicants for authorization, they have done their work, that have researched really the different applications of the hazardous chemicals and look whether there is a proper or safer alternative, are with this authorization essentially punished or discriminated against because, if you don't do your job right, you get away with it if this gets through, while if you do it, then your effort is not rewarded. And I think this is the wrong approach. And that's why I was happy to see that in the ECA decision, and I'm upset to see that the Commission nevertheless put forward, in a way, similar authorization. So it's a pity that we have to face this, but ultimately we need authorizations that really go and don't look for one-fit-all substitute, but look and go through use by use in order to do what REACH is supposed to do, protect health and environment of Europeans. Thank you.
Thank you. So, are there any requests from other groups? EPP, ECR? And that's it.
Thank you, Chair. Also, thank you for giving also those groups the floor that don't support the objection, because we had a similar vote in April, right before the election, and only by 10 votes, the objection, a similar one, was passed. So the Parliament is divided, and there should be heard both sides before, especially new colleagues make their opinion. So what is very clear, and I think that is undisputed, that in the end product that we have around us everywhere, in cars, in aviation, in many other products, there's no danger. There's no cancer risk for any consumer. The problem is that if there is exposure in the construction of these products, then it's dangerous. And that's why we have already strict rules. And with these applications, the applicants guarantee that even more strict rules are applied. And we see as EPP the problem that when we don't give this authorization, the products will still come to the European market, but they will be produced in third countries, Morocco, Turkey, and so on. And environment, and especially human health, are not protected enough. And I don't think we should only take care about the health of European citizens, but also those that produce the goods which we consume. And this application comes from SMEs. They did their utmost to prove that there are no alternatives. And there was even a public consultation only for this application, 5 SMEs. There was a public consultation, and I quote a Commission document: during the public consultation on Chronomet, there was no submission indicating any alternative. I would like the Commission to confirm that in this public consultation there was no submission. Nobody said that there is an alternative available, and that's why we as a EPP, we would support the Commission line and go against this objection. Thank you.
Thank you. Alexander?
Yeah, we are against too, Mr. Chairman, because we are unable to agree to the arguments put forward by the objectors and reject their claim that the implementing act does not correspond with the legal processes specified in the REACH regulation. The objectors state correctly that alternatives to chromium trioxide were found to be available for limited use. However, they neglect to mention that these alternatives do so at some loss to performance or in a manner that involves serious technical compromise. This leads me to believe that this objection is not about chromium trioxide or consistency with the basic test, but that it is a wholesale rejection of the socio-economic analysis in the risk assessment. Furthermore, the objector seems unwilling to consider the serious economic and social consequences of refusing authorization. Jobs and supply chains will be disrupted, businesses will become more inclined to move outside the EU, thereby shifting the issue to the other parts of the world where there are less demanding environmental regulations. The co-rapporteurs should be honest with the committee and demand a regulatory recast of the REACH regulation instead.
Thank you. I'm going to give the floor to the Commission. Mr. Flü from DG GROW.
Thank you, Chair. Good evening. Let me first start with the risk. This case, we heard it's a carcinogenic substance, but the risk assessment of ECHA concluded that the risk management measures and the conditions provided they are accepted by the applicant are appropriate. Coming secondly to the suitable alternatives in general, which were raised here. I would like to confirm, as it was raised by Mr. Liese, that indeed during the public consultation for this substance or for this application, no relevant submissions were made to ECHA. ECHA, or the Socio-Economic Analysis Committee, assessed and took into account other processes from earlier and similar applications. Functional chrome plating, this is not the first application which we have received. ECHA has already assessed a number of them, and they took into account the submissions made at that time. I would also like to come back to the ruling of the General Court as regards suitable alternatives. Suitable alternatives in general need to meet the following criteria. First, they must be safer. Secondly, They must be technically and economically feasible in the EU, and they have to be available to the applicant. It is not sufficient to have availability in abstracto or at laboratory level only. In this view, we have assessed the current case and also other applications, and we have concluded that no suitable alternatives in general are available, and therefore no substitution plan needs to be requested. We believe that the conclusions of the General Court as regards suitable alternatives have been met. On the uncertainties, it is true that CEA could not exclude technical feasibility of alternatives for some uses. But CEA concluded as well that it is likely that it is economically infeasible to switch to alternatives with limited range of applicability and required investments. And here they referred in particular to the fact that the applicants are SMEs. We are talking about 5 with an average number of workers of 18 workers.
Please go to your conclusion.
In summary, we have submitted similar comparable cases to the member states for vote. We have always received a qualified majority, and we are in the process of adopting some cases. We accept that no suitable alternatives exist in this and other cases, having carefully assessed a number of drafts after the court judgment. Similar cases were in aerospace and defense sector submitted and submitted to vote. For us, it's unclear why the resolution is now targeting this application submitted by 5 SMEs.
Okay, I'm sorry, but you're supposed to have 2 minutes. Now it's 3:30, okay. So if you could really conclude in 10 seconds.
One sentence. Adopting here this resolution would have also the consequence that we have to look again into cases which we have already submitted for a vote, and the impact would be large.
Thank you. So we are going to close this presentation. We will vote in a minute, and then we will, if the objection is adopted in ENVI, we will vote in plenary on Thursday.